Hello and welcome to Family Court. My name is Elizabeth Aiken and I'm a Family Court Case Manager. We have a program to help you get ready for your hearing. Court staff, judges, and a law enforcement officer will give you important information about your hearing today. You are to stay in the room for the entire class. You will be given a short break prior to your hearing. The person who files a request for relief from abuse is called the plaintiff. All of you in this room are defendants. You are called a defendant because a plaintiff is asking for an order against you. You probably have either been served with a temporary order for relief from abuse and notice of hearing, or a notice of hearing on the plaintiff's request for a final relief from abuse order. In this program, plaintiffs and defendants will all hear the same information in separate sessions. It is most likely that you and the plaintiff will not be allowed to talk with one another before going in front of the judge or judges. There may be several cases scheduled for the same time. The presiding judge will decide the order in which the cases will be heard. Court hearings are generally open to the public, so there may be other people present in the courtroom listening to the hearings. Children may not be allowed in the courtroom without permission from the judge. If the plaintiff has a lawyer today and you don't, you may ask the judge to reschedule so that you can decide whether to talk to a lawyer. If there was a temporary order, the judge will extend it to the next hearing date. Be sure to get your copy of the new temporary order prior to leaving. When this program is finished, there may be handouts and/or people with information you might find useful about topics such as domestic violence, substance abuse, and parent-child contact. You are encouraged, but not required, to take advantage of any community service that can help you. For most of you, the hearing today is about whether a final relief from abuse order will issue. Some of you may be here on a request to change an order. No matter why you are here, the information presented today should be helpful. Keep in mind that the purpose of this type of order is to provide safety where needed. Now, two judges will explain more about what happens when it's time for your hearing.
My name is Nancy Corsones, and I am a trial court judge in the state of Vermont. I am here today to tell you about your hearing and what to expect. This is a family court hearing, and any order issued today will be a family court order and not a criminal court order. For many of you, a temporary order was granted without a hearing. Just because there was a temporary order does not mean that the judges will grant a final order today. A judge decided that there was enough information in the plaintiff's sworn statement to grant an immediate order for safety. For some of you, the judge decided that there was no immediate urgency. The court today may still grant a final order. There are two ways that a final order may be issued. One is by agreement, and the other is after a hearing in which the judge or judges will hear testimony. First, I will describe the agreement method. If both people agree, the court can issue a final order without the need for either of you to testify about the events which have brought you here today. The terms will be decided by the court after input from both of you. These terms do not have to be the same terms that were in a temporary order. You should let the presiding judge know if you are willing to consider an agreed-upon order. The second way a final order may issue is after a hearing. If there is no agreement, a hearing is held where the judges will listen to the evidence given by both of you. The judges will then decide if the plaintiff's case has been proved and whether to issue a final order. If the case has not been proved, a final order will not be issued. If a hearing takes place, the judge will decide if your conduct meets the legal standard of abuse. Vermont law sets out specific requirements to prove abuse. They are attempting to cause physical harm, causing actual physical harm, placing another in fear of imminent serious physical harm, and abuse to children as stated in child protection laws. In addition, stalking, sexual assault, and exploitation of vulnerable adults, also as described in the law, may be the basis for this type of order. The plaintiff has the burden of proof. Because the plaintiff has asked for an order, plaintiff has to present believable facts to show that abuse has occurred and that there's a danger of further abuse. The judge or judges will listen carefully to both the plaintiff and you and any other witnesses before deciding the case. The court is not for or against either party because of the first written statement. The court is here to provide a fair hearing for both parties.
I'm Harold Eaton, Jr., a Vermont trial court judge. Now we will take a close look at what happens during the hearing itself. The presiding judge will control how people give testimony. Don't speak while another person is talking unless you have a legal objection. When listening to others, you may feel the person is not telling the truth. You may think you need to interrupt so the judge or judges know that you don't agree. However, you must wait for your turn. The judge or judges will not make a decision until both parties have been heard. Each of you must be ready to talk about what happened. This includes the date and time of any incident and who was present. Describe whether anyone was drinking or using drugs, whether there were any weapons, and exactly what happened. This includes what each of you said or did and what the effects were, including any injuries or medical treatment. The judge may ask about past incidents as well. Please remember, the purpose of this hearing is limited. It is about whether there has been abuse and whether an order is needed for future safety. You may usually testify only about things that you personally saw, felt, or heard. You can testify about what the plaintiff said, but not about what other people said. This is the concept of hearsay. There are some exceptions, and the presiding judge will decide whether they apply in your case. The presiding judge will decide whether any witnesses other than the parties will be allowed to testify. Witnesses will generally be asked to wait outside the courtroom until they are called. You should be aware that anything you say during this hearing can be used against you in any criminal case. The judge or judges will make a decision after listening to the testimony. If the judge or judges find that you abused the plaintiff and all requirements of the law have been met, a final order will be granted. If the plaintiff has not proved abuse and danger of further abuse, no order will be granted and the case will be dismissed. If the case is dismissed and an incident of abuse occurs afterward, the plaintiff may file a new request for an order. If the case is dismissed, you may still file another type of case to seek orders for custody, visitation, support, and property matters. The court staff can help you with forms.
Now I will talk about what is in an order. The purpose of a relief from abuse order is safety. Whether an order issues by agreement or after a contested hearing, it will state that you shall not abuse the plaintiff. Orders may also contain terms about contact, property matters, and children. First, I will talk about contact. The judge may order you to have no contact with the plaintiff and may prevent you from entering or living in the plaintiff's home and may prevent you from coming within a certain distance of the plaintiff. In some cases, the judge will allow contact or permit it under certain circumstances. To get final orders about property ownership, you will need to file a separate case. This type of case will not result in a final order on property rights, although the judge may decide how a person can get his or her belongings or other temporary matters. The court staff can direct you to the forms for filing a case about property matters. Depending on your situation, it may need to be filed in either family court or superior court. You may wish to get legal help. Now let's talk about children. If you and the plaintiff have minor children together, the judge may decide when and how you will see the children. This may range from an agreed-upon schedule, to public pickups and drop-offs, to supervised pickup and drop-offs, to supervised visitation, and in certain extreme cases, no contact at all. If the judge decides that you will get to see the children, the judge will generally set a schedule. Each of you should be ready to suggest a schedule that takes into consideration your work schedules, the children's school schedules, the comfort and safety of the children, and transportation. In some courts, the judge may have you meet with a visitation master who is trained to help you prepare a schedule. Any decision made today about custody and visitation is temporary only and is based upon limited information. In order for the long-term needs of the children to be met, you will need to file a parentage, divorce, separation, or civil dissolution action. You are encouraged to do so. Again, you should ask the court staff for the forms.
Now we will talk about the effect of a final order. The RFA order is only against you, the defendant. Only you can violate the order. If you violate an order, the state's attorney may charge you with a crime. In other words, even though an RFA order is a civil order, a violation of it is a crime. You may not purchase or possess firearms or ammunition while an RFA order is in effect. A violation may result in criminal charges in federal court. If you are not a United States citizen, an order may affect your legal status to remain in this country. This is true whether the order is issued by agreement or after decision by the judge. If you have any questions about firearms or immigration, you should get legal help. Let's talk about the difference between family court orders and criminal court orders. If either you or the plaintiff have been charged with or convicted of a crime, such as domestic assault, there may be conditions of release or probation conditions from criminal court, which is called the district court. If you or the plaintiff have any district court conditions of release or probation, those conditions will not be affected whether or not an RFA order is issued today. Similarly, any change or dismissal to an RFA order will not change any conditions of release or probation conditions. If there is a difference between a district court order and an RFA order on the same subject, you must obey the more strict order. For example, if one order says no contact and the other does not say anything about contact, you must obey the no contact order. Changes to district court orders must happen in district court, and changes to family court orders must happen in family court. The same judge may or may not sit in both courts and hear both cases. There are important things you must know about changes to RFA orders. You and the plaintiff cannot agree to ignore the order on your own. For example, if the order forbids you from entering the plaintiff's house and plaintiff agrees to let you enter the house, it is still a violation for you to go into the house. No one and no agreement can change the order. Only a judge can change the order. You may be arrested for violating an order that has not been changed by the court. Only a judge can change or end an order. If you want an order changed, you must file a written request at the family court. The court clerk and judiciary website have forms that you can use. Even if both of you agree to change parts of the order, that does not mean the judge will change the order. A hearing may be scheduled on any request. Now, a court staff person will tell you about what happens in the courtroom.
In the courtroom, there are 2 tables that face the judge or judges. The court officer will tell you where to sit. If you have a lawyer, he or she will sit with you. The presiding judge may allow an advocate or support person to sit with you, but that person is not usually allowed to speak with the judge. At the front of the courtroom, in addition to the presiding judge, there may also be 1 or 2 assistant judges. They help the presiding judge decide what happened and whether an order is needed. Each person will be sworn by the court officer. This means that both of you are under oath and must tell the truth. Only 1 person can talk at a time so that the judge can hear what you have to say. You will both have a chance to tell what happened. Everything that is said in court is recorded. The presiding judge may ask you to stand or allow you to sit. Speak clearly. When you talk to the judge or judges, say Your Honor or Judge. Always answer out loud so your answer can be heard. Don't just nod or shake your head. Take your time when answering. If you don't understand a question, say so. If you don't know an answer, say so. If you are giving dates, times, and places, be as specific as possible. The presiding judge controls the order in which people speak. Please wait until it is your turn before speaking. Both sides will be given an opportunity to be heard. Always speak directly to the judge or judges. Stop talking if the presiding judge tells you to do so. Do not interrupt or argue with the judges or other people. If you disagree with another person's testimony, wait until it is your turn to give information. If you have brought something with you that you want the judges to see, tell the presiding judge, who will explain what to do. The plaintiff is given a chance to look at it before the judges see it. The presiding judge will then decide if it will be used. If you have minor children with the plaintiff, please be thinking about visitation, what you want, and how it might work. You may want to ask that drop-offs and pickups or visits take place with help from another person, such as a relative or friend that you both trust, or a visitation center. A parent-child contact worksheet may be available to help you prepare. If you have questions during your hearing about what the judge is saying, try to ask at that time. Once an order has been signed by the judge, court staff cannot change it. Do not leave the courthouse without getting your copy of any order issued today. Ask any court staff if you have any questions. A final order is issued for a specific period of time. Check your order for the expiration date. If you want to change the order, a form is available at the Family Court Clerk's office or at the Judiciary website. Filing a request does not change the order. The order remains unchanged until a judge rules on the request. If plaintiff wants to extend the order beyond the expiration date, plaintiff may file a request to extend the order. If you have questions about what happened in court today, you should get legal help. You will now hear from a law enforcement officer about what you should know if an order is issued. An order may or may not be issued today, but if it is, this is important information.
My name is Robert Clark, and I am a law enforcement officer in the state of Vermont. I will be talking to you about what you can expect if a judge signs a relief from abuse order. It is not automatic that an order will be issued. That is something that will be decided by the judge or the judges. All police officers and sheriffs have authority to enforce any order that the court issues today. The requirements of the order must be followed. Violation of the order is a crime and may result in your arrest. All RFA orders require you not to abuse the plaintiff. You may also be ordered not to contact the plaintiff in specific ways. You may be ordered to stay a certain distance away from the plaintiff and from the plaintiff's work, home, school, or vehicle. You may be ordered not to follow the plaintiff or enter the plaintiff's home. It is your responsibility to know what is in the order. You should keep a copy with you. If a final order is granted today, it must be served on you to be enforceable. A court officer will give you a copy in hand. It is our job to enforce the order and to ensure the safety of the plaintiff. It is your responsibility to know what's in the order so that you do not violate it. It is important that you understand that if a final order is granted today, it is only against you, and only you can violate that order. The plaintiff cannot violate a relief from abuse order. If you do not follow the order, you can be charged with a crime of violating an RFA order. If you are ordered to stay a specific distance away from the plaintiff and you meet the plaintiff accidentally, you must cross the street, leave the store, or just get away from the situation entirely. If the order does not allow telephone contact and the plaintiff calls you, hang up the telephone. Same goes for email and text messages. If you have a criminal case in court, any order issued today will not change any condition of release or probation. If you're on probation and then violate any order issued today, you may be charged with a violation of probation in criminal court. If a relief from abuse order is granted today, possession or purchase of firearms or ammunition by you while the order is in effect may be a federal crime. If there are questions about this, please get legal advice. If you want to change an order, you must file a written request with the court. Until the court order changes, the police will enforce the order as written. For example, if the order says no contact and the plaintiff wants to talk to you or see you, that will not be a defense. Only the judge can change that order. If the plaintiff's request for a final RFA order is not granted, any temporary order expires. The fact that the temporary order expires does not have any effect on any other orders, such as conditions of release or probation. Family court orders also stay in effect. Now we will tell you what specific information the plaintiffs are hearing in their presentation. If a final order is granted today, it must be served on the defendant to be enforceable. If the order prohibits all contact and the plaintiff needs to talk to the defendant, plaintiff must file a written request with the court to change the order. A written request must be filed with the court to change that order for the contact. Otherwise, the defendant will be in violation of the order and may be arrested, whether the plaintiff wants that or not. If there is no order after today's hearing, but the plaintiff still feels unsafe, the plaintiff may call the police. Our job is to protect the persons from abuse with or without an order. People often ask what to do when unexpected contact occurs. If there is no contact order, it is the defendant's responsibility to leave if there is unexpected contact. For example, if a plaintiff is sitting in a restaurant and you come in, you must leave. If you do not leave, the plaintiff should call the police. If the order requires you to stay 100 feet away from the plaintiff and both of you show up at a school event, then you must either stay 100 feet away or leave entirely. However, you should not be put in a position of unintentionally violating the order. If the plaintiff walks into a mini-mart and you are paying at the counter, the plaintiff could leave until the defendant is done and left the area. If you deliberately make the plaintiff feel unsafe, the plaintiff should call the police. If an order says that you or the plaintiff must have a law enforcement officer with you to get your things from a former house, make those arrangements directly with your police or sheriff. You may have to pay for that service. Orders are put on a nationwide list. This means that any officer can look and see if there's an order. Any order issued in Vermont is enforceable in every state. Any order will remain in effect until the expiration of that order. Remember, only the court can change the order. The order may not be changed by you or the plaintiff, even if you both agree. It can only be changed after a request is filed with the court and decided by a judge. Our goal is to ensure everyone's safety and protection.
This ends the court's program to help you get ready for your hearing. Someone from your local court will show you the next step.